I'm sorry we've been held up by technical hitches, but Mr. Rowe.
Thank you, my Lord, and of course not at all. Just before I get going, a couple of practical points, my Lord. I gather that a note which was served on us rather late last night by our learned friends will have also made its way to the board. May not have yet reached the board itself, somewhere in this building. It's a short chronology. Well, at any rate, on a brief perusal on my part, it appears to be a short chronology of the coming into force of the Constitution.
Yes, it arrived by email a minute ago.
Well, I haven't had a chance to do more than glance at it. On the basis of that glance, it appears to be neutral and relatively helpful, and I won't say any more about it, and your Lordships and Ladyship can read it at leisure some other time. If on reading it more closely, it appears to contain something materially that we disagree with, then we might seek to put a riposte in, but
Yes.
I hope not to have to do that.
Can I just say that there is a certain degree of slackness in the way documents are filed and the timeliness of which they're filed in the Privy Council, and it's something I'm minded to do something about. There is a sense, of course, in which it's sometimes better late than never, but obviously it's better not late at all.
My Lords, in this particular case, it deals with a point which arose only in an argument on Monday. It's to do with essentially the ECHR and how it interweaves with the introduction of the Constitution, deal with the points that were being raised about should one, and to what extent should one, adopt ECHR jurisprudence in construing the Constitution. It doesn't argue the point, it just says this is how, that this was the sequence of events when Trinidad became a colony, when the UK signed up, and so on and so forth. It doesn't do anything else.
I see.
My Lord, the other practical point I wanted to mention is that I understand from our learned friends that, having used up all of their time that would have been a time for a reply in the course of their submissions yesterday, they have no time in this appeal for a reply. They would wish to take a bit of the time they would otherwise have on the other appeal to say something by way of reply to me, and that's a matter for them.
Yes, and you'll be here for that.
Yes, of course. Yeah. So, my Lord, that deals with that aspect of things. I propose to make this morning, I think, 6 fairly short points by way of concluding my submissions, and then I will try to leave some time for my learned friend Mr. Hussain, who wishes to follow on some other matters related to our case. And the 6 short points are these. First of all, I want to respond briefly to the suggestion made by our learned friend Mr. Ram Logan on Monday, that the ordinance is not in fact an existing law because of the alteration in 1965 by which the minister was substituted for the board. Secondly, I wanted to deal with the wording of section 6. Is there any significance in the wording shall not invalidate? And might it be said, well, what's being tried to be done here is not invalidation of the ordinance or anything under it, but some different reading, and therefore does that help the appellants? Thirdly, I want to deal squarely with Francis, and in particular with the dissenting opinions in Francis that say that proportionality is not the right test for ordinary legislation and its compatibility with the Constitution. Fourthly, I want to deal with the proposition that this rule that we're concerned with in this appeal had to be brought in under the emergency powers section of the Constitution. Fifthly, with the suggestion that the rule abrogated, abridged or infringed the constitutional rights that are engaged. I submit that it didn't. And sixthly, and very briefly, with the suggestion that the rule was inconsistent with section 1 of the Constitution because not of a sort that should exist in a democratic state. So I'll try and get through all of that as efficiently as I can. So far as the first point is concerned, my Lord, the short answer to that can be found in a case which I'll take the board to in a moment. Just to get matters, as it were, in order to start with. In our written case, we set out the origin of the change from Central Board of Health, being the entity which can make the rules like the present one, to the minister. It's on page 4441. It's our first footnote in our case, but I wanted to correct something which, on looking into the point and having assumed a bit more significance in the light of Mr. Ram Logan's submissions, appears to be wrong. We say paragraph 63K. It's actually just paragraph K, so you can cross out the 63. It's paragraph K, and it's actually Schedule 8, or in the formulation they had at the time, the 6th schedule.
I'm sorry, this is page...
Page 4441.
Yes, and what's the amendment you ask us to make?
Well, if you cross out 63...
63, footnote 1.
Just leave K in its place, and cross out 8 and write 6. And at the risk of incurring a further reprimand, we might, if it's important, put that in separately. Put the document in separately later. But I don't think much turns on it.
So we don't have it in the.
We don't have it in the bundle. But all it says is in the ordinance, wherever you see the word board, read minister. And the short point as to why that doesn't render the ordinance doesn't render it a new law, or stops it from being why it doesn't stop it from being an existing law, we can find in the case of Johnson, which is at 2981 in the bundle of authorities. This is Johnson and Balwant against the Attorney General, 2981, as I say. Judgment of Lord Roger, speaking for himself, Lord Walker, Lady Hale, Lord Collins and Lord Kerr in 2009. And very briefly, this was a case that involved, among other things, a 1968 regulation, which we can see set out on I think the third page of the report, so 2984. Regulation 58, towards the top of that page.
This was a sex discrimination case, wasn't it?
Yes, it was, my lord, that's right. This was a 1968 regulation that said that the Commission may terminate the appointment of a female police officer who is married on the grounds that her family obligations are affecting the efficient performance of her duties. And the board dismissed what Lord Roger described at paragraph 8 as an ingenious argument presented by Mr. Knox QC to the effect that it wasn't discriminatory, but went on to reject in any event the proposition that it was unconstitutional on the basis that it was an existing law. And we see that if we track through to paragraph 12 of the judgment, the conclusion that there is discrimination by reason of sex affecting the right to equality before the law seems preferable. I think there was one other way it could have been put. But the point is not crucial, since either contention involves ignoring sections 6, 1 and 2 of the Constitution, which are then set out. The effect, paragraph 13, is that of section 6 as an existing law is not to be invalidated by section 4 of the Constitution, and not to be regarded as inconsistent with the Constitution by reason of anything in section 4. To put it another way, it makes an existing law constitutional. And then, importantly for our purposes, does it matter? Did it matter in that case that we were concerned with the court was concerned with the regulation which had been brought in 1968? So, in other words, after the first Constitution, the first Independence Constitution. Answer: no, because of section 18 of the 1976 Act, which is set out in full there at paragraph 15, which, as your lordships and your ladyship can see, makes provision for what happens for enactments passed under the former Constitution, that's the under the 1962 Constitution, which have not, before the appointed day, before the commencement of the 76 Constitution, been declared by a competent court to be void by reason of any inconsistency with any provision of the former Constitution. And I'll perhaps, given the time pressures, leave the board to reflect on that at a later occasion if necessary. But the upshot is, that, as Lord Roger says in the rest of that paragraph, this section means that since the regulations had not been declared void by reason of inconsistency with section 1 of the 1962 Constitution, they were deemed to have been validly made and to have had full force and effect as part of the law immediately before the commencement of the Constitution in 1976. This section neatly excludes the line of argument which succeeded in Bow and the Queen, where there was no similar provision in the Bahamas. That had involved a similar situation of two constitutions, but no equivalent of section 18. So going back to our case, that explains, in my submission, why, in fact, it's a matter of common ground in the statement of facts and issues in our case, why that concession on the part of the appellants was correct in the first instance, that the ordinance as a whole is to be regarded as an existing law. And the fact that it was altered in one way in 1965 doesn't change that, because it was not declared void by a court
I'm not sure why you even need Johnson for that. I mean, the definition of existing law in section 6(3) says a law that had effect as part of the law of Trinidad and Tobago immediately before the commencement of this constitution. Which
well, I suppose because perhaps I'm overcomplicating it by anticipating an argument that might say, oh yes, but before the commencement of the Constitution, it had already been invalidated. It could have been. Nobody did, but it could have been challenged.
Right, okay, I understand.
And Section 18 knocks out that argument.
Is there a provision somewhere that deals with amendments? I mean, if there's a sort of wholesale amendment of in 1990, for example, of an act which was in force in 1965 or 1950, does that count as existing law, or I thought there was a special provision?
It's really, my lady, in Section 6 itself, Section 6(2), which talks about amendments, enactments that repeal and reenact with modifications, and I mean the overall gist of it, I think, is essentially if it's something which is substantively new, then it's not existing.
Yes, but if it's
a tidying up exercise, then it can still be an existing law. It's page 1289, section 6 of the 76 Constitution.
My Lord, my Lady, if it insists, I accept the effect of section 18 in this case. I don't. Mr. Rose made this point. I'm not in a position to say that section 18. I can get around section 18. If you look at the position in 1976, it hadn't been challenged by 1976. End of all. There are other points, but not that point.
My Lord, that example in the Johnson case is also, I submit, provides something of an answer to the point that was made on Monday, or the question that was raised on Monday by Lord Sales about the relationship between our case and the various dicta about the living instrument, the development of the Constitution, the avoidance of austerity, the austerity of tabulated legalism, etc. The answer is simply that there are certain provisions which don't attract that way of looking at things, because they are simply concrete provisions about what the law is or is not. And if I need authority for that, it's the well-known statement by Lord Hoffman on behalf of the board in the case of Boyce.
Yeah.
Another authority that's not in the bundle, but it's quoted from at length in Francis, which I'll be turning to in a moment, on page 2744. Amongst those who take an interest in these things, quite well known.
Is Boyce an existing law case?
Yes.
Yes.
Boyce was.
Yeah. So I'm not quite sure that deals with the Fisher point, if we can put it like that. I mean, there's quite a lot of authority, including from Trinidad and Tobago, that says the Constitution is a living instrument, refers directly to Fisher, the Fisher approach.
Yes, but I think the difference is that the fundamental rights, as stated, are the things that can develop as a living tree, but the existing law provision cannot change its meaning.
I see. Is that the point?
It has a meaning in 1962 and 1976, and that meaning is the same in 2022.
Yes.
That is the point that Lord Hoffman makes in Boyce.
Yes, that I follow. Forgive me.
And one sees that in the passage from Boyce, which is quoted, as it happens, in Francis at 2744 in the bundle. It's quite a long passage. I won't take time reading it all out, but the critical passage for our purposes is equally, Lord Hoffman says, equally trite as the proposition that not all parts of the Constitution allow themselves to be judicially adapted to changes in attitude in society in the same way. Some provisions are not expressed in general or abstract terms which invite judicial participation in giving them practical concrete content. They're concrete and specific. And Lord Hoffman gave the now dated example of the Constitution of Barbados saying that Her Majesty the Queen shall be the head of state. And so that couldn't be changed by judicial intervention. It had to be changed by Parliament, changing the Constitution, as indeed it later did.
It was.
So that's the answer in my submission to that point. My second point, briefly, was about the way in which Section 6 of the Constitution is worded, the use of the language shall not invalidate. And that's a point that was picked up in Matthew, which your lordships do have in the bundle, and that is at the relevant passage is at 3261. And one perhaps needs to have up at the same time in a separate tab the second supplemental bundle at page 10, which shows you what the 1962 Constitution looked like in this regard.
What's the distinction between shall not apply and shall not invalidate?
Yes.
Yeah, and the court in Matthew said it was a distinction without a difference.
Yes, it doesn't make a difference. So there's no mileage in my submission from the appellant's point of view. Excuse me. In saying that there's some important difference there. So, my Lord, my third point, and Francis. And my learned friends placed some emphasis on Francis and the way in which the minority in Francis, at any rate, said that proportionality was not the appropriate approach. Excuse me. My Lord, there are a number of objections to the approach of the minority in Francis. I should say, by way of preface, that actually what we're concerned with here is an extended obiter dictum, rather than, strictly speaking, rather than what would have been a judgment, even if it had formed the majority judgment, because Francis was a case not about ordinary legislation, but about legislation that had been passed explicitly under Section 13 of the Constitution as being inconsistent with rights, but it was said, nevertheless, was reasonably justifiable. It was a rule that said that if you were caught with more than a certain quantity of a dangerous drug, you had to go to prison for 25 years, regardless of whatever mitigation there might have been. And in my submission, there are a number of objections to that approach in Francis. The first is that it treats Suraj from the board as having laid down a new standard, whereas in fact that is not the case. And we make this point in our written case, and I'll take your lordships to it briefly, but it's the case of, the case that illustrates that is Alain Fort, excuse me, which in our case is at 4460. And I can probably take it from there, actually, most conveniently, rather than going into the authorities. That was a case about a car that had been illegally parked and taken away, and the state was demanding money for its return under the scheme that applied for illegally parked cars. So a fairly humdrum case on the facts in one sense, one might think, but it raised a constitutional issue because it was said, well, that's inconsistent with the right to property. And we see the dictum from Lord Nichols, which I've set out in our written case. The court is concerned to see whether in the particular case a fair balance is struck between the requirements of the general interest of the community and the requirements of the protection of the fundamental rights of the individual, which is classic, which is a classic instance of the way in which courts in human rights cases have to balance the non-absolute rights of the individual against the rights of the community. And as we point out in the written case in the next paragraph, that proposition is actually accepted by the majority in the Francis case. They say it was long accepted, as you can see, because of the competing interests of a democracy, that the rights conferred under sections 4 and 5 are not absolute. And to the extent they existed prior to the independent constitution never were, they must for the most part yield for public interest. Not every limitation on a fundamental right by the legislature or the executive will necessarily amount to an infringement for the purposes of section 14 of the Constitution. Nor, in my submission, will it amount to an abridgment, abrogation, or infringement for the purposes of sections 4 and 5 of the Constitution.
Can I just ask about the citation there? Because I printed out the copy of Francis in the bundle, and that,
yes, that's
where,
a bad
slightly strangely, the majority judgment comes second, and
yep,
that paragraph I think is 205. Anyway, I just wanted
Yes, no,
to
you're looking right.
understand why
I was going to come to that.
we're-
Actually, yes, that's a bad reference because it should be 2678. Sorry, 2768.
But why are there two versions?
Because there was the minority judgment and a majority judgment, and as originally handed down, the paragraph numbering started again.
Okay.
The majority judgment. So there are two para 49s.
But just as a very technical point, presumably we should be using now the reported case in the West Indian reports.
Yes.
Right. Okay. Good. That's what I've got.
Yeah. So no, that's right, my lord. So really, you should go to. I haven't got it right, but whatever the paragraph number is in the.
Well, the page is 2768.
Yeah.
And it's the top of page 2769. It's paragraph 205, I think.
That's right. Yeah. It's been renumbered by the reporter. But it's now, yeah, it's in the West Indian report, so that's the version that ought to be used. Paragraph 205. Yeah.
And in fact, they cite other authority as well.
Yes.
Domestic authority,
Yep.
which is to the same effect.
Yes. So, my lord, that's my first objection, as it were, to the minority approach in Francis. It's not right to treat Suraj as having sort of laid down this new standard from on high, out of nowhere. The second objection is that it proceeds on the premise, that is, the minority opinion proceeds on the premise that the rights are absolute. Or at any rate, it relies on the fact that they're laid down in the Constitution in absolute terms. And we can see that if we look in the minority judgment in Francis. For example, right at the beginning, on page 2688, paragraph 2, towards the bottom of paragraph 2 by letter G. In our opinion, the Constitution elects and enacts a clear bias, a permissive preference for the upholding of the fundamental rights provisions, stated by deliberate choice in absolute and unfettered terms, and clear, specific and concrete restraints on the power of the executive or the legislature to limit or restrict those rights and freedoms.
Forgive me, the page number?
2688, my lord.
Thank you.
Now, of course, it's true to say that
And sorry, just to add paragraph 151, they return to that point, page 2753.
yes, that's right.
So what they say is they're contrasting it with the Canadian model, which incorporated in the wording of the rights the restrictions, and they say, well, it was section 6 that introduces the restrictions that are being referred to as impingements rather than infringements, laws of defamation and such like.
Yes, well, I'm not sure they would be right to contrast it with the Canadian model, because, of course, the Canadian, well, it depends which Canadian model one means. The Canadian Bill of Rights of 1960 was, of course, adopted more or less verbatim into the Trinidad and Tobago Constitution. But that it's certainly true that there are other instruments. Many of the other Commonwealth constitutions say more or less in the same breath, when they say such and such a right shall exist, they say, but subject to the overall general right of the community to place such restrictions as are. There are different formulations.
But anyway, it rather makes the point, underlines the point you're making, because the minority here are going out of their way to say these are absolute rights, contrast them with the Canadian position. But the point you're emphasising is their approach is these rights are absolute.
Yes,
and that's is whether it's right or not.
And that's simply, in my submission, unsound. I mean, of course, it's true to say that they are. If by their absolute you mean, well, it doesn't say in the Constitution that they are subject to the rights of others. That's true, but one only has to look at the list of rights that are set down in the Constitution as being recognised and declared to exist and to continue to exist, to see that they can't possibly all be absolute rights, because it doesn't make any sense. You can't have the right of freedom of movement. Can't be a right for everybody to have freedom of movement in all circumstances, otherwise the prisons would be emptied, etc. One can multiply all sorts of examples like that. So it's just an entirely false premise in my submission. The third difficulty, and there are other examples.
You may want to come back to this at some point, but the document we received, just as we were taking our place this morning, includes extracts from the Wooding Commission that preceded the 1976 Commission, which would seem to support your contention. It talks about the rights, recommending qualified rights, an approach which adopts a pattern of the ECHR, and essentially the advantage of that sort of approach being that you can then have regard to the law of a much wider family of constitutions, and indeed the case law of the Strasbourg Court as well.
Well, I may take up the invitation to have a look at that in more detail and come back, but I'm grateful. But my essential point is that it's just not right to say these are absolute rights. And I mean, if one can think of other cases that would have been argued quite differently if they were. I mean, my learned friend's victory on behalf of the taxi drivers in the Paponet case, based on legitimate expectation that certain interferences with their property rights wouldn't take place, would have been entirely unnecessary. One wouldn't have needed to go down that road at all. One could have simply said, well, they had absolute rights to property. But clearly that couldn't be done. It had to be done a different way. So that's the second problem with Francis. The third problem is, in my submission, with the minority opinion, it fails to give any coherent account of how, bearing in mind that the rights are not and cannot be absolute, you deal with conflicts between rights and other interests, or between rights. And that's why, in the course of my learned friend's submissions, my learned friend is driven to attempt a variety of different formulations. Well, there are some exceptions because they're traditional, there are some exceptions because they are ordinary rather than extraordinary, etc., etc. And
so you're saying that these regulations are just like defamation or rules that you can impound someone's car if they park in the wrong spot? You think these restrictions are akin to that level of restriction?
Well, my lady, my primary point is that these regulations, because of their source in an existing law, are not
no, I know that's
amenable to being challenged.
Submission.
But if I'm wrong about that, or in any by way of fallback position, no, I say these regulations were a reasonable and proportionate response to the crisis that was faced by the government at the time. And I'll come on. That's really one of my next points to come on to seek to make that submission good. I don't say, I mean, I don't say they are no more remarkable than rules about parking. Of course, I don't say that. But they were regulations that were brought in the context of a particular crisis for a particular reason. They're very limited in time. Of course, they constituted an interference with people's ability to assemble with each other. But that was a proportionate and legitimate and justified interference for the minister to impose in all the circumstances. But can I come and deal with that in a moment when I get to that aspect of my submissions, lady, because I want to look at the case of Dolan in that context. My fourth point was that it's not correct to say that the rule can only be accomplished by using the provisions in Section 7 and following of the Constitution, which provide for emergencies. We deal with this in our written case at page 4465 and following. And what seems to be being said is that it's analogous to the Kaiser and Fire Brigades Union type of case, where, granted that there was perhaps, if there was perhaps the power to do it under the ordinance, nevertheless the effect of the emergency provisions regime being available is that the emergency provisions regime becomes compulsory. The difficulty with that, in my submission, is first of all, that there's nothing in the text of the Constitution that tells you that the emergency provisions regime is the exclusive method by which laws may be made or executive action may be taken to deal with an emergency. And if that had been the intention of the framers, then they would have said so, and they don't say so. So one is driven back to trying to see whether there is, I suppose, by analogy with the Fire Brigades Union and Kaiser type cases, is there a sort of necessary implication that the framers' intention was to take out of the toolkit that the government had available to it
Well, it begins Section 7 by saying without prejudice to the power of Parliament.
Yes.
It's clearly not exhaustive.
No. My Lord, it's, well, respectfully agree with that observation. It's plainly not exhaustive. And the difficulty with it, I mean, I've made this point in the case, is that it's so broad in its possible field of operation. It might be different if one could see, I suppose, if there were a provision in the Constitution that said, should a particular circumstance occur, then the government shall have the power to do X, Y, or Z. We might say, well, that's a lex specialis, and implicitly the government can only use that set of provisions and can't resort to its general powers under pre-existing legislation. But the Constitution doesn't say that, and indeed it goes out of its way to make sure it doesn't say that, because if one looks at Section 8, which deals with, this is page 1290, deals with what a period of public emergency is, it drafts it in deliberately broad terms. Section 8, paragraph 2, subsection 2, a proclamation made by the President under subsection 1 shall not be effective unless it contains a declaration that the President is satisfied of various things, which are in the alternative. But if one looks at the one which is closest to our case, that a public emergency has arisen as a result of the occurrence of any earthquake, hurricane, flood, fire, outbreak of pestilence, or of infectious disease, or other calamity, whether similar to the foregoing or not, what one notices, I submit, is that it's been deliberately drawn in very, very broad terms. Our learned friends naturally spot the words pestilence or infectious disease and say, well, look, this means that the provision could have been used, the emergency powers could have been used, as indeed we've heard they were on another occasion in connection with coronavirus. But it doesn't follow from that they had to be. And in fact, if one looks at the way the draftsman has done it, other calamity, whether similar to the foregoing or not, which is clearly aimed to knock out the eustem generis principle of construction. So essentially, almost anything which the President can rationally conclude is a calamity generates the right to make a proclamation, which in turn generates the public emergency, which in turn enables these powers. But to say that it follows that the framers of the Constitution laid down that these powers had to be used doesn't work, precisely because of the breadth of it. As I say, if it was a narrow targeted provision, you might say that's the lex specialis, and implicitly the framers have said that's what you've got to use, but they don't do that. And so that's why in my submission this is...
I mean, it could also produce an outcome which would be, one might think, highly detrimental to the public interest, because if someone is saying, well, this is a lex specialis, you could then get drawn into arguments about whether the President ought rationally to have declared an emergency rather than use the other toolkit in the public health ordinance with a view to quashing what might have been done very sensibly under the public health ordinance in the face of a difficulty.
Well, respect that must be right. And I suppose also what one would... that reading would encourage the government to use the draconian emergency powers rather than looking in its existing toolkit to see whether there's something that doesn't involve declaring a public emergency. So that submission doesn't work in my submission. Then my fifth point, why do I say that this rule did not infringe? If I'm wrong about the existing law point, and this does have to be considered for compatibility with sections 4 and 5 of the Constitution, why is it wrong to say that there was an infringement or an abrogation or abridgment or infringement of the constitutional rights? Well, I've already made my submission that it is correct to say that one does look at this legislation, that is to say the rule that we're concerned with, through the lens of what we might call the usual human rights tests for these things: proportionality, the reasonableness of the provision. But of course one has to accept that this was an extraordinary and draconian set of measures that were brought in, and I wouldn't for a moment want to be thought to be saying, well, this was no more consequential in practical terms than rules about not being allowed to park in certain parts of the port of Spain. Of course not. But the proper approach of my submission is first of all to identify specifically what is it that what freedoms were infringed and how were they infringed and can one justify it. And as I said, I think briefly on Monday, our learned friends say, well, it's freedom of movement, freedom of association, freedom of assembly. It's really only the last one in my submission because, as I've said, freedom of movement is not touched at all by this. Any one individual, or indeed any group of up to 4 or 5 individuals can go wherever they like under the existing law. Freedom of association is, and I won't go to it, but there's a reference in our printed case to a European case called McFeely. It's page 4462, para 50 of our case. The case itself you can find at 3385. McFeely, which was a European convention case that says that freedom of association is not about physical meeting, it's about the ability to form organisations with other people, none of which was touched by the fact that you couldn't physically meet, because happily by the time coronavirus came along, people who invent technology had invented so many technologies that enabled lots of meetings to carry on, albeit perhaps suboptimally. So we're really concerned with freedom of assembly. And I wanted in this context then to take the board, if I might, to Dolan, which is helpful because it's a pretty full consideration of this issue in the English context, but it touches on many of the same issues. Dolan is at page 2572. Which was a decision of the Court of Appeal in England, well, in England and Wales, but concerned with the regulations solely applying in England. For what it's worth, and I appreciate the answer may be not necessarily very much because it was merely a dismissal of an application for permission to appeal, but for what it's worth, one can recall at 2594 that an application for permission to appeal to the Supreme Court was refused by, I think, 2 of the members of the present Constitution back in December of 2020. Dolan was concerned with various regulations. It was a bit of an unwieldy piece of legislation in the end, which attracted some criticism for that. But one of the things it was concerned with was Regulation 7 of the then English coronavirus regulations, the effect of which is set out at paragraph 20 in the joint judgment of the court, presided over by the Lord Chief Justice. Paragraph 20 on page 2577. Regulation 7, in its original form, prohibited gatherings in a public place of more than 2 people unless they came from the same household or for specified purposes such as work. So actually more draconian than the Trinidad and Tobago regulation we're looking at. And then it goes on to describe various amendments that those who lived through it in the United Kingdom, or certainly in England, will recall. There are a variety of challenges, some of which are not relevant because they were pure public law challenges, and some of which are not relevant because they were challenges under different provisions of the European Convention. But so far as we're concerned, what's of interest, I submit, is what we see at 2591, which concerns Article 11 of the Convention, which, as the Court reminds us in Para 101, guarantees the right to peaceful assembly and association. On the face of it, Regulation 7, as originally enacted, I'm reading from Para 101, might be thought to have taken away this right altogether. Nevertheless, it must always be recalled that Regulation 9(1)A of the English regulations provided a general defence of reasonable excuse. And that's relevant to our case because the regulations we're concerned with contained a defence of reasonable justification. Without reasonable, one wasn't allowed to meet up without reasonable justification. And the court then quotes an authority from the Court of Appeal in England and Wales called the National Resident Landlords Association, where Lord Justice Hickinbottom summarised the applicable principles and noted that a distinction must be made between challenges under the HRA, this was of course a Human Rights Act case, to legislation, and challenges to the application of that legislation to a particular case. So challenges to the legislation itself and challenges to the application of the legislation to a particular case. And he said that legislation will not be unjustified and so not unlawful unless it is incapable of being operated in a proportionate way in all or nearly all cases. And that, in my submission, is quite an important insight, and it's plainly right, because if one is saying, as these appellants do, not well, the government acted disproportionately to our constitutional rights in applying it to us, because they singled us out for strict enforcement, whereas other people got away with it, for example, or because there was some improper reason for us being chosen, or because perhaps we were not properly given the benefit of reasonable justification. We had some excuse that we wanted to put forward, we weren't allowed to put forward. If that's not what's being said, and it's not being said here, what instead is being said is simply the regulation is invalid to court, and that's it, then one has to ask, well, is that going to be the case in all cases? And we can see how the Court of Appeal in Dolan dealt with that proposition in the context of the English regulation. Para 103, the first difficulty is that Mr. Havers submits the regulations must necessarily be regarded as incompatible with Article 11 in all or nearly all circumstances. It's difficult to see how that can be so when the regulations themselves include the inbuilt exception of reasonable excuse. That would necessarily focus attention on the particular facts of a given case in the event of an alleged breach. In our view, the regulations cannot be regarded as incompatible with Article 11, given the express possibility of an exception where there was a reasonable excuse. It may well be that in the vast majority of cases there will be no reasonable excuse for a breach of Regulation 7 as originally enacted. There were powerful public interests which lay behind the enactment of Regulation 7, given the gravity of the pandemic in late March. And then there's reference to the Ziegler case, lawful excuse being the provision in the Highways Act and being similar. It was said by the Court of Appeal to reasonable excuse in the English coronavirus regulations. Ziegler, of course, as several members of the board I think know from personal experiences, went to the Supreme Court, and we've set out briefly in our written case, by way of reminder, if it's needed, what the Supreme Court said about that. But it again illustrates the point that if one's looking at an overall challenge saying this is invalid in all circumstances, one's, in my submission, on pretty stony ground.
I think in Ziegler we were unanimous that one did interpret the relevant provision by reference to the convention case law and concept.
Yes, I think there was some difference of emphasis as to quite how you did it, which I don't think I propose to get into either way, but yes, that's right.
Well, how does that apply here?
Because, my lady, each instance upon which, under which somebody, in each occasion on which somebody is prosecuted for breach of the rule in Trinidad and Tobago, will give rise to the opportunity for that individual to say, either to say under the terms of the regulations, I had reasonable justification for what I was doing. And that would seem to open up two possibilities. One is purely as a matter of forgetting about the Constitution, purely as a matter of ordinary construction of the rule. One might say, well, okay, I wasn't doing any of the specific things which are allowed for in the regulation, like working as a police officer or something, but I was doing something else. Suppose there was an emergency and I'd run out with a series of other people to try and put a fire out. That was a reasonable justification for gathering in more than 5 people. Or it might be said, well, this was necessarily a gathering to exercise some constitutional right. Perhaps it was a protest, and that would leave the local courts in the first instance with having to make a decision as to whether reading reasonable justification compatibly with the Constitution, that protest was something which implicitly was permitted under the terms of the rule, as read compatibly with the Constitution. Now, I don't say that to suggest that necessarily every political protest would be justified, and I don't shy away from the fact that would leave the court making some difficult value judgments about the particular facts. But what it illustrates in my submission is that one can't simply say, as the appellants do, well, these regulations are invalid under the Constitution, full stop. It's a matter of fact and degree in every case, and that's why I submit their challenge doesn't work. There's also reference in Dolan to the issue of proportionality specifically. It's done very briefly, but it's in paragraph 105, where the Court of Appeal say there are also powerful arguments that the restrictions, time limited and subject to review as they were in any event proportionate. And that is a short reference to, I think, to what then Mr. Justice Lewis had said at first instance. I don't think the first instance judgment is in the bundle, and I won't try and send or pass up a copy now, but your Lordships and your Ladyship might want to look at what Mr. Justice Lewis said at first instance. It's in particular dealt with at paragraphs 93 to 96 of the first instance judgment. And perhaps unsurprisingly, it makes the point that the government, in enacting the regulations that the court was concerned with in Dolan, was faced with an unprecedented pandemic in circumstances where at the time there was no known treatment, no known vaccine, and the disease was known to be fatal in a significant number of cases and to spread very readily between people when they were gathered together. And so in those circumstances, said Mr. Justice Lewis, it could not be said, indeed Mr. Justice Lewis said it couldn't even arguably be said, because it was an application for permission to proceed with judicial review, couldn't be said that, that the regulations were disproportionate. And it's also relevant to note that the Court of Appeal thought it was important that the regulations in England were time limited and required the government to review them. The regulations in Trinidad that we're concerned with, Trinidad and Tobago that we're concerned with, were extremely time limited because, as the board may recall from my own friend's presentation of them on Monday, they each had, when they came in, a fixed cut-off date that was in some cases only a matter of days away. The one that we're concerned with, I think the date on which the appellants were said to have infringed the rule, was in early April in the context of regulations that were enacted on the 6th of April and expired on the 30th of April. And that's another factor in my respectful submission that makes it difficult to contend that these regulations were disproportionate. Of course, it might or might not be possible in years to come with hindsight to say that it was all unnecessary, and who knows, some people might say that, some others might say otherwise, but that's neither here nor there when one comes to looking at the proportionality of the government's approach to it. And finally, from Dolan at para 106, we see the court saying that the Treasury Counsel had reminded the court that the Human Rights Act was primary legislation, whereas the regulations are subordinate legislation. And this comes back to my point about how one would construe in a real case, how the application of the rule to a particular instance. So, in my respectful submission, if one gets as far as having to look at the constitutionality of the rule, if I'm wrong about it, the fact that it's an existing law, meaning that one doesn't have to, then the clear outcome, which was not reached either way in the courts below because they rested entirely on the existing law point, but the clear outcome in my respectful submission is that that these regulations were proportionate.
Is there somewhere you can, the proportionality test can mean all different sorts of things. Is there somewhere you can point us to what you say is the test that needs to be applied when the board is considering whether these regulations infringe the Constitution? Is there some formulation you can point to?
Well, my lady, I think I'd probably commend the well-established proportionality tests in the common law jurisprudence, Bank Mellat, and the I think I'm right to say four-stage test that one sees outlined there. Reasonable relationship between the for proper purpose, reasonable relationship, essentially whether it goes no further than.
Bank Mellat took it from JCPC jurisprudence.
Yes, it did. Your Lordship's right, of course.
Not the de Freitas case we've been looking at, but another.
You're right. Another de Freitas case. Yeah, from I think Antigua. So yes, so it's a well-trodden road.
How do you say it relates to the reasonable justification requirements under Section 7 and 13?
Does your Lordship mean Section 7 or Section 13?
Or both. They both have reasonable justification.
Put it in front of me.
The same test, different test?
Oh yes, Section 7 not shown to be reasonably justifiable for the purpose of dealing with the situation, and Section 13 again, not shown to be reasonably justifiable in a society that has a proper respect for the rights and freedoms of the individual. Well, in order to get to excuse me, in order to get to those provisions, one, of course, has to have gone through the other routes. So either one's looking at emergency legislation passed under Section 7 and following because there is a public emergency, or one is looking at legislation that's been passed with a special majority under Section 13. Well, I suspect the answer maybe I would give is probably rather similar to the thought that Lord Sales was exploring on Monday, my Lord. One approaches it, the test. I mean, ultimately, it still remains ultimately in those situations for the court to say, is this reasonably justifiable for the purpose of dealing with the situation that exists, if one's under Section 7? If it's Section 13 special majority, is this something which is reasonably justifiable in a society that has a proper respect for the rights and freedoms of the individual? It may well be right that in that context one's also looking at a proportionality type analysis, but of course one's doing it against the context of, in Section 7, there having been a ex hypothesi proper declaration of an emergency. I mean, one could challenge the declaration of emergency, presumably on the grounds of rationality, if it really was obvious it wasn't an emergency, it wasn't a calamity. In the case of Section 13, one would be looking at it in the context where a supermajority of Parliament has decided that this legislation in the public interest requires to be enacted. And it would in some respects be similar to the position that obtains in the United Kingdom, where you have Parliament saying in primary legislation, our view of where the public interest lies in immigration, for example, is ... But the fact that you have that exercise needing to take place in those contexts doesn't mean that you always must get to that exercise. That the only way in which it can be the only way in which legislation which interferes to any extent with people's rights or ability to exercise their freedoms is through either of those two routes.
But that's not really, I don't find that answer terribly helpful. If the framework envisages that it's possible to have legislation which really infringes, not just impinges on Section 4, is an infringement of Section 4, but is reasonably justifiable. Now, I asked you, well, what's the test for whether it really infringes? What is your proportionality test? You say it's Bank-Mellett, the four-stage test. Well, I hear what you say. But then when you say, well, what's the reasonable justification test later, you say, well, it has to be seen in the same in the context of that. Yes, of course it does. But if it's not the Bank-Mellett test at that stage, what is it?
Well, it's... I'm not sure I'm saying it isn't the Bank-Mellett. I mean,
well, if it's Bank-Mellett at both stages, then how do you get to a situation where you have an infringement, but yet it's in fact reasonably justifiable?
Because the same sorts of considerations come into play. This is hypothetical as regards our case, because we're concerned with all legislation.
But the nub of the case was, I think, for...
Well, how does the court go about dealing with applying the tests in Section 7 and Section 13? It has to apply the plain language of the Constitution. It's for the government. Just stick to Section 13 for the moment, if I may. It's for the government to say. Well, actually, it's for the person challenging, the way it's put, shown not to be reasonably justifiable. But it's for the person challenging the act to say this is not reasonably justifiable in a society that has a proper respect for the rights and freedoms of the individual. Indeed, that was the argument in Francis, which I think succeeded as regards the 25-year minimum sentence if you were caught carrying more than a kilogram of marijuana. The underlying assumption or one might say, is that by the time one gets into that territory, one is dealing with matters which, by common, certainly in the case of Section 13, by common consent, does infringe the rights under Section 4 and 5 of the Constitution.
I wonder if one can't say that it's absolutely clear that a test of whether something is reasonably justifiable is not a proportionality test of the kind that's been applied to Commonwealth constitutions. I don't think we have Bank Mellet in front of us, but the first point to be made about that is that although it was laying down a test to be applied in the context of the Human Rights Act, it's not the Strasbourg test. That's acknowledged in Bank Mellet itself. It said this is not the way Strasbourg looks at this.
Yes.
This is a domestic approach derived from JCPC jurisprudence.
Yes.
On the application of constitutions, mostly in Commonwealth, and in particular the De Freitas, the analysis by Lord Clyde in De Freitas. That's the first point to be made. The second is that when you go through the 4 stages, and you end up with the final balancing of the competing interests in order to decide whether the measure is proportionate. That is a judicial assessment of whether it is proportionate or disproportionate, and the court is the arbiter of that. It's a matter of judicial judgment. There's no Wednesbury aspect to it at all.
No.
And I mean, that's the point that Lord Bingham made very clear in Wang, I think. Now, if on the other hand, you're looking at a test of whether something is reasonably justifiable, what you're asking is whether it is reasonably capable of justification.
Yes.
Obviously, it's a court that's having to make that assessment of whether it's reasonably capable of justification, but the court isn't itself deciding whether it is justified or not.
Yes.
It's standing back and asking whether it's within a band or spectrum of measures which could reasonably be justified. And if it's within that band, then it passes muster.
Yes.
I wonder if perhaps that's the answer, that if you like, you could say it's a less strict test. You could also say it's a test that gives inherently greater weight to the assessment of the primary decision maker, in this case either the President under Section 7 or Parliament under Section 13.
Yes, well, I would respectfully adopt that, and to the extent that I either said or was understood to say, and I may well have been the first one, that it's just the same Bank Mellet test, sort of second time round under Section 13, but with super-added considerations. That's probably not right. I mean, it is on reflection a different exercise the one's concerned with in circumstances.
I think it's also true to say that the fact that something has the support of a supermajority in Parliament is obviously a factor that the court is going to take into account, just as it does under a proportionality assessment, attach weight to whether something is, for example, a statutory instrument or is primary legislation.
Yes.
Just out of the separation of powers aspect of applying a constitution or our own domestic Human Rights Act.
Yes. Yes, well, I'm grateful for that, for those observations, which I would respectfully adopt. So I hope...
And just to pursue that, going across then to Section 7, I mean, again, I wonder whether it might be said that under the regime for parliamentary supervision of whether there is a public emergency, essentially a similar argument applies, that one's moved from the realm of just the judgment of the minister to the judgment of Parliament, that
yes.
there is a public emergency in place.
Yes.
And then the argument becomes quite similar.
Yes, and therefore it's likely to be more difficult to say this is invalidated by the Constitution.
Yeah.
But presumably your researchers have not thrown up a case in Trinidad and Tobago where something has been held by the court to be an infringement of the Constitution, but nonetheless has gone through the Section 13 route and been held by the court then to be reasonably justifiable.
I'm reasonably confident there must be such cases. I don't have them at my fingertips. I'm about to be followed by my friend Mr. Hussain, who may know the answer to that. But
well, that might be interesting to see how the court approaches the two different stages.
I see that, my lady. I agree. So I hope that that concludes, I think, what I wanted to say about about my fifth point. Is the rule in the present case inconsistent with the Constitution, even if it has to be considered on its own merits and not insulated therefrom by being existing law? I say no for those reasons. I can take the sixth point in one sentence. Is it right to say that because the rule was brought in, or can one say the bringing of the rule in by the minister was incompatible with the status of Trinidad and Tobago as a democratic state? In my submission, that's a fanciful point. It's not anywhere near the sort of territory where the courts have said this is incompatible with the very essence of the state as a democratic state. It doesn't improperly take power away from the judiciary, to give the classic example. It just makes very time-limited, draconian admittedly, but in the minister's view, vital provision for dealing with an unprecedented situation. And it can hardly be said that that disqualifies Trinidad and Tobago from being called a democratic state, any more than one could say the same thing about the many other states that adopted similar measures at the same time for the same reasons. So, my Lord, unless I can assist the board further, those on this matter are my submissions.
Yes, well, certainly the jurisprudence on Section 1, I think the leading case is the Koirati one.
Yes.
And that is a case about the withdrawal of bail
Yes.
from certain offences. And there the reasoning, as I recall, was that bail was intrinsically within the province of the judiciary, and essentially Section 1 was seen as an underpinning of the separation of powers.
Yes.
And you're saying this is very different territory.
Yes, completely.
Yes, I don't think is there much other jurisprudence relying on Section 1, as far as you can recall?
I think there's a recent Trinidad and Tobago authority, again to do with bail,
yes.
Making a similar point.
But again, that's essentially saying separation of powers is intrinsic within a democratic state.
Yes, yes. As far as I'm aware, that's really the only territory that it's been successfully deployed in.
Thank you.
Yes, thank you very much, Mr. Rowe.
Thank you, my Lord.
Thank you very much. Thank you very much, my lords and my lady. I would like very much to start where my learned friend left off, and perhaps I can address some of the issues that was raised in respect to that. And I would like to begin by looking at Section 6, Section 13, Section 6, Section 13, and Sections 7 to 12, as the case may be, because it is my respectful submission that apart from Section 53 and 54, which calls for the amendment of the Constitution, those were the three areas in which the courts, which the Parliament or the Minister had options to intervene in respect of the COVID-19 pandemic. In respect of Section 6, he might deploy a save law, which he did in this particular case. The save law is immunized from challenge under sections 4 and 5 of the Constitution. And that is the opening words of section 6. In other words, you can't challenge it as against the fundamental rights and freedoms in section 6. What is interesting about section 6 is that there's no provision there to either review regulations or to check the regulations and see whether they are compliant. But there are other mechanisms. The first mechanism in respect of the public health ordinance was that the president has to make a proclamation. So the president has to be satisfied that we're in a period where there's an infectious disease, and that is one check. The second check is the minister is responsible to the parliament, and the minister has to answer questions. The third check, of course, is that it is an issue surely of collective responsibility on the part of the parliament as to how and when the president should be advised to make this proclamation. And ultimately, the fourth check, of course, is in the court of public opinion. The court of public opinion. Now, that is in contrast to the emergency regulations under 7, where it provides that the regulations are made pursuant to a proclamation by the president. Again, there's a proclamation, and there's a reasonable justifiability test. If we look at section 7.3, reasonably justifiable for the purpose of dealing with the situation that exists during the emergency. There's a provision for the regulations to be extended on 2 occasions by the Parliament for 3 months each by a simple majority, and thereafter, if it has to go beyond that, we need a 3/5 majority in the Parliament, and it goes forward. Now, the reasonable justifiability test that is set out in respect of emergency regulations at 7.3 is, in my submission, a test that is slightly higher, and only slightly higher, than what is the proportionality test that is dealt with in the situation, in the case, first of all, of Oaks out of Canada, that was subsequently used in Nyamburi in Zimbabwe. It was subsequently used by Francis in the PC. It was subsequently adopted in Bank Mellat in the domestic jurisprudence of the UK. It was subsequently refined in Wang, as the case may be. It was used in Surat. It's the same test that is used throughout the common law world to determine whether legislation has a legitimate aim and whether the circumstances are such that the legislation is proportionate to the situation. In the case of 7.3, the important words are not to be shown to be reasonably justifiable. So therefore, the person who is making the application to the court to impugn these regulations, that person has to show it is not to be reasonably justifiable for the purpose of dealing with the situation that exists during that period. So it's a situational test based for limited circumstances, that is the period being mentioned, and the onus is placed upon the person who is making the application. Now, so there are built-in measures there as to the length of the emergency and as to how the regulation should be approached. For example, if you have a pandemic and you incarcerate persons for whatever reasons because of political views, clearly that cannot reach the standard required by Section 73, to give an example, which comes off the top of my head. The third mechanism which the minister might deploy is the Section 13 mechanism. That is, the minister may pass legislation, and that legislation is inconsistent with 4 and 5, as is the legislation in 6, the same legislation, as is the emergency regulations, as the case may be, as is Section 13. So Section 13 does a number of things. First of all, Section 13 admits to the fact that Sections 4 and 5 is breached. It has to be stated in the legislation to that effect. The second thing, the fact that the Parliament has stated so doesn't require the court to make an independent finding that 4 and 5 is breached. The second measure is there must be a certificate attached to the legislation.
So I thought that in Francis it said, the court said that they do have to, that it is open to the attorney to challenge whether in fact Parliament's been over pessimistic, and that the court can decide, despite the express statement by
Yes,
Parliament.
I agree with that, Millie. This is exactly what I'm saying. Even though Parliament has said so, the court has to decide whether the circumstances are thus.
So the Parliament has to make a declaration.
They can't just make a declaration. That is reviewable. So the third thing that has to be done is you need to get a 3/5 majority, and there has to be a certificate to that effect. But more than that, even if all of that is done, the person who is applying to challenge the legislation must show that the legislation is not reasonably justifiable in a society that has a proper respect for the rights and freedoms of the individuals. It's up to the person who is applying again. But it's much broader and wider than what is contained in Section 7.3, because it does not apply for a limited period. It applies for all times. And therefore, Francis is an illustration of that. You have to go further than Suraj and Bank Mellat. It has to be something arbitrary, capricious, oppressive, and something that goes beyond the ordinary. And therefore, Parliament has created a mechanism for the violation of 4 and 5 with the permission of the Parliament by primary legislation in circumstances where the situation demands it, and all of these measures are in place. So, my Lord Reid, I think, answered the question respectfully to show that there's a much higher threshold, and the legislation is protected, and the courts have a right of review to determine, as Milady Rose said, to determine whether it is reasonably justifiable. So the classic case on that, Milady, is Francis. The classic case is Francis. And in Francis, that issue was considered by the majority. The legislation was passed with a supermajority, but what happened is the legislation provided for sentences in respect of very heavy sentences for small amounts of marijuana and other drugs. And the court said, no, you can't do that. That is oppressive, that is capricious, that is arbitrary, you can't go. Now, might I return to my original point? And the issue is the legislature had a choice. These choices were 53 or 54. Now, which choice the legislature makes is a matter of executive deference, as the case may be. The minister may have chosen the state of emergency regulations, if he wishes, under 7 to 12. He might have gone for primary legislation under Section 13, or he might have deployed existing legislation that is best suited to the particular circumstances here, because a state of emergency regulations allows a wide range of powers to be issued. What he has done, he has gone for the least intrusive option. And the least intrusive option in this case is the public health regulations, because it is confined to infectious diseases or dangerous infectious diseases, as the case may be. And that is an issue in respect of proportionality. How does he respond to the situation? That's the first point. The second point in terms of proportionality and in terms of how it has to be viewed is Section 105 of the Public Health Ordinance, because the minister can't make regulations outside of Section 105. Section 105 cribs him in terms of the length and breadth and nature and circumference and latitude of regulations he can make. And that is what happened in this particular case, set against the circumstances which gave rise to the pandemic. And that's the second point in that. And that's a proportionality point, as well as it is an ultra-virus point. Now, I would like to spend just a few minutes clarifying an issue in which the state of Trinidad and Tobago is interested in. Of course, we say, and I support absolutely my learned friend's point, that the legislation and the initiative is proportionate. But I want to approach it another way. And I'll give an example because it will best illustrate what I have to say, and will probably throw some light on what the Court of Appeal said. If we have legislation which is saved under Section 6, and therefore cannot be challenged under 4 and 5, it means this. It means the Parliament or the constitution makers would have authorized that legislation, notwithstanding the fact it is in breach of 4 and 5. Now, if we have regulations made under an authorized statute that permits a breach of 4 and 5, the elephant in the room, or the big question, if I may use a more proper term, is whether legislation which is authorized, which breaches sections 4 and 5, can now authorize regulations that are in breach of 4 and 5. And that is really the point, because the enabling statute, that is the save law, which violates 4 and 5, enables the legislation to be made which violates 4 and 5, movement and assembly and mask and all of the other things. Now, it's not an issue of the regulations being saved. We admit to that. That's not an issue. It is not an issue, secondly, as to whether the regulations are ultra-virus. That is not an issue in the case. The issue in the case is whether the regulations conformant with 105, because there is no ultra-virus point, and authorized under Section 6, which violates 4 and 5, whether those regulations are permissible in the circumstances and be constitutionally compliant. Now, the second point is this. If the minister had gone under had proceeded under Section 7 to 12, the emergency regulations, those regulations would also be non-compliant with 4 and 5 because they're emergency regulations. Now, is it then, in those circumstances, that those regulations are challengeable under 4 and 5, or do you go to the reasonably justifiable limited tests set out in Section 7.3? And the answer is this. The answer is found in Section 7.3. Shall have effect even though inconsistent with 4 and 5, except insofar as its provisions may be shown not to be reasonably justifiable for the purpose of dealing with the situation that exists during that period. So the Constitution is put aside, and we don't challenge the regulations on the basis of being breached in 4 and 5, but we challenge the regulations on the reasonable justifiability point for that particular period. Similarly, my lords and my lady, if they had gone to Section 13, if the enabling legislation met the constitutional strictures spelled out in Section 13, that is, the 3/5 majority, the certificate, and all of that, right? And the regulations permit, and notwithstanding Section 4 and 5, they've gone through the modalities and passed it under 4 and 5, and the regulations are within the scope of the authorized derogation or infringement of the rights that are set out in 4 and 5. Is it now that the courts are allowed to review those regulations and the constitutional values of those regulations?
Mr. Hussain, could I just ask you a question about the provisos to Section 7.3 and Section 13.1? Because it seems that they put the onus, I'm not sure it's right to...
Accept that, the case
no, if I could just ask my question. They seem to put the onus or the burden of proof, if that's the right word, on the person challenging the regulations.
Absolutely.
What I wanted to ask is there any jurisprudence applicable in Trinidad and Tobago which shows that if you have regulations or other laws or other measures which interfere with the rights in Section 4, that there is an onus on the government to justify those under the proportionality test that is said to be applicable under.
I think the opposite is the case, because the cases bear this out. Started with Mutu in the 1970s. There's a presumption of constitutionality.
Right.
There's a presumption of constitutionality. You start from that presumption when you are examining legislation. But the constitution makers must have known that. And this is why the onus is now placed on the applicant in respect of 1307(3) to show that is reasonably justifiable in the circumstances described therein.
The reason for raising it is under the ECHR, the expectation would be that if an interference is shown, the onus is on the state to show that it's justified and is proportionate. If that were the approach in Trinidad and Tobago in relation to the ordinary proportionality test, which Mr. Rose says applies under sections 4 and 5, I mean, that would be another ground of distinction in the test or the approach applicable
Absolutely, absolutely, Millard.
But you say not so.
Not so, Millard.
No.
And we can provide a case law if you wish. Now, query. The large issue is this, and the issue is whether legislation under Section 13, emergency regulations under Section 7 to 12, and a save law, which are all authorized violations of 4 and 5, and which fall within the compass and the varies of the enabling legislation, whether, and are therefore intra-varies, whether the minister might not deploy regulations that violate 4 and 5 because of the fact that he is authorized to do so, or whether all such legislation must undergo a various scrutiny under 4 and 5, notwithstanding the fact that the enabling legislation has authorized him to do so. Now, it is my respectful submission that that is the core of the matter. On the other limb of the argument, and my answer is no. What the court has to do before it goes to proportionality is the court has to examine whether the regulations fall within the framework of the Authorizing Act, and the regulations are made under the section which authorizes the regulations to be made. And that is the question. You see, my lords, all the provisions of the Constitution, in the first chapter at least, preference can't be given to any other section. And that's set out very clearly in Lord Hoffman's decision in Matthews. There's equality in terms of the sections. So Section 6 has to be read with Sections 1 and Sections 4 and Sections 5 and Sections 13. There's no hierarchy of preferences in terms of the sections. They are all at a level of equilibrium. The court's function is to synchronize all of those provisions and find in it a common thread where they can be read, where there can be a harmonious construction of those provisions. So therefore, respectfully, my first point is that what a minister has to do is, instead of having to have every regulation where someone feels a grief challenge because they have met in a house where they say they are ministering to Venezuelans, etc., 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 and then challenge the regulations and say the regulations are ultra-virus, and then seek damages. That is not the way to go. We accept absolutely that if the regulations are enforced and the enforcement of the regulations provide an issue, the first thing that has to be decided is, does the minister have the power to make those regulations by the enabling statute? And that is the question in this case. It's not a question of examining the minutiae of the circumstances. That's for the criminal courts. That's for the trial. What this court is concerned with is the varies of the regulations. And you can't jump from the varies of the legislation and say, look here, we're entitled to damages and costs and what have you,
Well, you say we're concerned with the varies of the regulation, but why? I mean, why are you concerned simply with varies? No one is disputing that under the public health ordinance, no one is disputing that the regulations were intra varies that ordinance. The question is, were they constitutional? Were they existing law?
I accept that absolutely, my Lord. My Lord, put it this way: if you look at 5, Section 5, and I'm happy my Lord asked the question. It's not existing law, but 5 says, except as is otherwise expressly provided. In this chapter and in Section 54. Now, my reading of Section 5.1, in terms of a harmonious construction, is that Section 5.1 applies to save law under 6. It provides for emergency regulations under 7 to 12. It provides for Section 13 legislation. And it also provides for a situation where the enabling legislation has a permissible breach of 4 and 5 of the Constitution. And in compliance with the regulation made within the varies of the authorized infraction of 4 and 5, that's a proviso, that is an express provision made for the protection of the legislation. It can't constitute an abrogation, abridgment, or infringement because it is constitutionally underpinned. It is constitutionally underpinned. The constitutional underpinning doesn't come from the fact that the regulations are not an existing law. The constitutional underpinning stems from the fact that sections 4 and 5 are excluded from a consideration of a save law, but at the same time, the save legislation authorizes this abrogation, abridgment, or infringement.
Yes, but Section 6 doesn't say nothing in Sections 4 and 5 shall invalidate an existing law or regulations made under an existing law.
I accept that absolutely, my Lord. I accept that absolutely. But you see, my Lord, it has to be read as a whole. And therefore, when you look at 5 has to be read harmoniously with 6. And a 5 and 6 harmonious reading will mean that if you allow a regulation made properly under 6 that is varies, that is consistent with the restrictions imposed by a save law, and you allow a challenge date on 4 and 5, it will make nonsense of the powers granted in sections 105 of the Public Health Ordinance. In other words, my Lord, if I may say this, if you are authorized to deploy 105 in the circumstances described therein, you can't challenge the existing law, but you can challenge the regulations as being in violations of 4 and 5. It will render the Public Health Ordinance to a position where it can't function absolutely, because the effect of the save law is to authorize it by its regulations to violate 4 and 5. Otherwise, the legislation is cribbed, it's useless, and it has very little value to the executive.
Well, but that is contrary to Mr. Rowe's argument that you assess the proportionality of the restrictions that are imposed in the light of the circumstances of the emergency, the pandemic. It doesn't render it.
That's an alternative argument.
Yes.
If you would not,
or it may be an alternative argument, but it's contrary to your. It's certainly contrary to the one you're now making.
or if it is, my Lord, fine. If my Lord is not with me. If my lords are not with me, yes, in terms of my interpretation of 5 and 6 put together, I accept absolutely, or in addition to, the fact that it can be a proportionality assessment of the legislation as the case may be.
Well, Mr. Rowe took us to paragraph 102 of Dolan, which refers to legislation is not unlawful unless it is being incapable of being operated in a proportionate way in all or nearly all cases. But just looking at 105 and all the things that can be the subject of regulations: promotion of cleanliness, ventilation and disinfection, speedy burial, provision of medical aid and accommodation. Do you say those things can't be done without infringing section 4 and 5?
Well, there's more to it, Millie. If I may, can I see 105? There are some parts that can be done without infringing rights, but there are some parts, for example, the restraint, the segregation, the isolation of persons, the removal to the hospital. Remember, these regulations are drafted to cater for all manners of contagion. This was probably drafted in 1917, around the time of the Spanish flu, as the case may be. As I understand it, it's well before my time. The speedy burial, you're doing, some persons like to hold a body for a long time, house-to-house visitation and inspections. So what Section 5 does is Section 5 authorizes very substantial restraints upon persons. It erodes fundamental rights, sexual settled in sections 4 and 5, and there's no dispute about that. Now, the issue is whether, if the Constitution permits for the preservation of this legislation, it has to also permit for the working of the legislation by the invoking of the powers in 105 that are in breach of contemporary standards of liberty in an evolving society, if I may use the American case law on that. And it permits of regulations of that type. And that is as high as I will put it, Milady. Now, could I just, I know I'm running out of time, so I just need to touch a few short points and move on. Just a few short points, my lads. The second point I wish to make is that if we look at the case of Doolan, and it's there in Doolan, I can find the passage in a short while. What happened in Doolan was there was a range of options open to the minister. And the case very clearly states, and if I may take you the electronic bundle 2587, it says, in any event that Sir James also submits, it is simply not to the point that regulations might have been made under any other act. The critical issue which arises before this court is whether the 1984 Act, as amended, confers upon the Secretary of State to make the regulations which he did. We have come to the clear conclusion that it does. That conclusion is not affected by the fact that the Secretary of State might have had power to make the regulations under the 2004 Act as well. So it's a matter of executive choice, whether you go under the regulations, and it is my respectful submission. It is my respectful submission that there has to be deference to the executive, especially when there is a very pointed, specialized piece of legislation to deal with this issue, which authorizes the infringements of rights. Now, I say this, it does not matter that the regimes spelled out in Section 6, Section 7 to 12, and Section 13, and Sections 53 and 54 provides different mechanisms for oversight. The Parliament has approved the limited oversight requirements in respect of Section 6. We admit freely to the fact that the level of oversight in respect of our deployed legislation under Section 6 might be less. But that is not the issue. The issue is whether it is constitutionally approved, and whether the minister used a constitutionally approved method, and whether in those circumstances he did the most intrusive thing, and in any event he had a choice. So that is my second point. The third point I wish to make milady, is
Well,
that...
if you can make it quite briefly, Mr. Hussain, because we are needing to get started on Maharaj.
Okay. Well, I'll make it in 3 minutes, my lord. My little friends mentioned yesterday 2 local judgments in which there was some doubt cast on the Suraj test. And that is the case of Achille Charles, which is going to come to my lord. And the second case is this case, the Suraj case. Now, the presiding judge in both Francis, who was in the participated in the minority in that case, he was also the presiding judge in Suraj, I beg your pardon, and he was also the presiding judge in Achille Charles. So when we look at those 2 other authorities, we see that the minority position is now, and I hate to use this word, being continuously canvassed along the line, and therefore, in my respectful submission, we shouldn't go there. And the final point I want to make, my lord, is that Section 1 cannot trump Section 6 because they have to be read together. And Section 1 deals with broad macro legal concepts, rule of law, and its subset, the separation of powers. So when there is a specific piece of specific process spelled out in Section 6, you can't import into Section 6 a requirement to comply with Section 1 because they are at one level. And the final issue on that is that take, for example, separation of powers, which is found in Section 1. Lord Hoffman said specifically in Matthews that separation of powers is not a supra-constitutional principle that is deployed in all single cases. Coriati had special facts. They could not reach the level of entrenchment necessary to override the separation of powers. So therefore, you can't deploy it everywhere where there's a lacuna, or you think there's a lacuna, or to improve the quality of the jurisprudence. It's used as an interpretation device to augment situations which are ambiguous, or which there are none in this case. And I bring my submissions to a close. I hope I've been helpful, my lords and my lady. Thank you very much.
Thank you very much, Mr. Hussain.
May I just take 10 seconds before we completely quit the field, just in answer, just 2 references, if I may, in answer to Lord Sales's questions about the moving burden of proof. The board might want to have a look at Webster and Maharaj. Webster is 4318, and Maharaj is 3684.
And do they bear out the point Mr. Hussain said that there's a presumption of constitutionality?
They're not inconsistent with that, but they do talk about, they're both discrimination cases, but they do talk about the need for the state to justify interferences once interferences have been established.
Yeah, there are 2 other authorities on the point that I should perhaps mention. One is a case called Grant and the Queen, which is 2007. 1 appeal cases, page 1, and it cites and relies on a Trinidad case, Mutu and the Attorney General of Trinidad and Tobago, which is 1979, 1 Weekly Law Reports, 1334. Both cases are actually referenced in Surat. Lady Hale cites the 2 passages in question. Let me see. Yeah, in paragraph 45, where she says it's a strong thing indeed to rule that legislation passed by a democratic parliament establishing a new type of judicial body, which is what she was dealing with, is unconstitutional. The constitutionality of a parliamentary enactment is presumed unless it is shown to be unconstitutional, and the burden on a party seeking to prove invalidity is a heavy one. See Grant, paragraph 15, citing Mutu at 1338 to 1339. On the other hand, she says, the Constitution itself must be given a broad and purposive construction, see Fisher.
Yes.
Thank you.
No, I'm great.
Right. Well, thank you all very much. I think we're now ready to turn to Mr. Maharaj's appeal, and I think Mr. Ramlogan, are you addressing us first?
Mrs. Knox has...
Oh, Mr. Knox.
My Lord, I think Mr. Rowe mentioned
You're going to use up some of your...
we were going to use up some of our Maharaj time
Oh, I see.
with our reply.
To reply. Oh, very well.
My Lords, I had planned to be about 30 minutes in the reply, and
Yes.
I've mentioned this to my learned friends, and they were content with that. So if the board is, I would propose to follow that course. My Lords, first of all, what would appear to be the principal point of the debate, the question of surat and proportionality. And that is, can ordinary legislation derogate from the fundamental rights and freedoms, no matter to what extent, as long as it is proportionate and pursues a legitimate objective? The state says yes, we say no. We say you've got to go the Section 13 route. That is, in essence, the big debate between us. Now, my Lords, yesterday afternoon, with the considerable assistance of Mr. Riley, we thought it might be helpful to put together just a brief chronology so one can see how the ECHR and the Trinidad and Tobago Constitution, just as a matter of sequence of events, interwove, and how it came about that Trinidad came to adopt the 1962 Constitution in the 1962 Constitution. And my Lords, my Lady, if you go to the first page, we simply set out Article 63, the ECHR. Article 1 is the important one. Article 1, sub-Article 1 is the important part of that. The state may extend the ECHR to all or any of the territories for whose international relations it's responsible. And on the 23rd of October 53, the UK gave notice under Article 63 extending it to 42 overseas territories. And we understand, although we haven't actually been able to trace down, that that included Trinidad and Tobago. We have no reason to doubt that, but I think Lord Sales said from his recollection of the previous case, the religious cases in which we gave judgment last week, Trinidad was one of them. In 1960, the Canadian Bill of Rights comes into effect.
And just ask me, do we have that in the bundle?
The Canadian Bill of Rights?
Yes.
No, we don't have that in the bundle, my Lords. I didn't want to put in any more material, but we obviously will provide it. It's referred to in the religious, I can't remember the name of the case, Robertson, I think, and we can see that there. On the 1st of October 1960, the Nigerian Constitution came into effect on independence, and that used the ECHR as its template. And similar constitutions came into effect shortly afterwards in the following years, British Guyana and the Jamaican constitutions. So that was the template generally used in the early 60s. On the 28th of June 1961, while Trinidad was still a colony, it brought in a new constitution, which provided now for a proper legislature. Before then, just a bicameral legislature. Before then, there'd just been a legislative council. But at that point, no fundamental rights and freedoms were declared, but the preamble to the order recorded the people's faith in the fundamental rights and freedoms. And one might say at that point they're thinking about the ECHR. Section 17 of the order, however, essentially said the Queen can revoke that constitution. So, of course, at that point, Trinidad remains a colony. Then, on the 18th of April, 1962, the West Indies Act is passed. It replaces various other acts, but the important point is Section 5, which effectively gives Her Majesty the power to make provision in relation to the colonies. And you'll see the word colonies is referred to in the second line. And it's pursuant to that power, in Section 5, that the constitutional order is eventually brought into effect. I'll just go straight to that for the moment. Which comes into effect on the 24th of August 1962. I've jumped ahead a bit. And that is shortly after the Trinidad and Tobago Independence Act on the 1st of August 1962 was passed by the UK Parliament. which provides, as from the 31st of August 1962, Her Majesty's Government will have no responsibility for the Government of Trinidad and Tobago, and nothing thereafter that the UK Parliament does will extend to Trinidad and Tobago. And there's a schedule to that Act which provides that no law made by Trinidad after the 31st of August shall be void on the ground of repugnancy to English law. So the short point is, from the 31st of August 1962, Trinidad ceases to be a colony and the UK ceases to have any responsibility for it. Now, in the build-up to independence, there were quite a few meetings, both in London and in the Port of Spain, and I just want to draw your attention, essentially, what was proposed by the constitutional advisor to the Cabinet was that the ECHR model be adopted. And I've taken these references, when you see at the end, for instance, of Para 2 in April 1962, 2703-43, that's a reference to the electronic bundle, and these are points made in the judgment in Francis. And so Ellis Clark, who's the advisor of the Cabinet, and he entrusted with drafting the proposed constitution, presented a draft to the meeting, and that was in the ECHR format. In response to that, Mr. Hugh Wooding for the Bar Association proposed that the Canadian Bill of Rights should be taken as the model. And then Sir Ellis Clark concluding the debate, and we get this from Francis, and you can see what he says. He says the model that's been put forward by the Bar Association simply gives Parliament far too little power to interfere with fundamental rights and freedoms, because it seems his model allowed only for that to be done in the event of a state of emergency. That was the objection put forward by Ellis Clark. And then the Court of Appeal, having noted that, you'll see paragraph 5, they say that a compromise was then reached, under which the Canadian Bill of Rights model is adopted, that is to say, what became section 1 and 2 of the 62 Constitution. But Ellis Clark's insistence on parliamentary power was included in sections 3, 4 and 5. And
that's really the minority's sort of own conclusion or gloss upon what happened. Well, I think it's very debatable whether their interpretation of the Constitution does that, in fact, represent a compromise between the views of Mr. Wooding and Mr. Clark, as he then was. Well, because Mr. Clark went out of his way. I'm looking at page 2704, where
yes,
the court sets out a rather more extended extract. Yes, says that you need a wide power in Parliament to override rights.
Yes.
Which very much echoes with the point made by the majority in Francis, pointing to section 53 of the Constitution and the power of Parliament to make laws for the good order and governance of Trinidad and Tobago.
Yes, my lord, I don't think there was ever any doubt that an equivalent to section 53 was going to be in the Constitution in any event. Right. The question was, how can you override, to what degree of protection do you give to the fundamental rights and freedoms?
Right. But my point was that the court, the minority, in paragraph 45, describing it as a compromise and then saying it's a compromise as we now interpret the Constitution, I think is really expressing a conclusion rather than an historical fact.
Yes, my lord. I can't say that there was some sort of something that people said, okay, well, let's call it quits on the following basis. My lord, it may have been more complicated than that, but I've just taken this from the Court of Appeal judgment. But the important point is there's a conscious decision to reject the ECHR model, and there is a decision to put in A, the emergency powers provision, and B, section 13, which is obviously section 5, I think, at the time, but now section 13. And that is the genesis, we say, of section 13. It is there, unusually in these constitutions, to give Parliament a power to derogate from the fundamental rights and freedoms. And what we say you get out of this, in broad terms, is that from the 31st of August 1962, the UK is not responsible for Trinidad and Tobago, and the ECHR is not applicable to Trinidad and Tobago by virtue of the UK's membership of the Convention. And that, my lords, is by contrast with the position in Bermuda and the Cayman Islands, which was the position you considered in the two recent cases, I think, of Day and Ferguson, in which you gave judgment. So that, we say, is a very important distinction. And we also say that there is no suggestion, as we are, so far as we're aware, between 1962 and 1976, that a proportionality test was to apply in relation to legislation as a means of passing ordinary legislation rather than resort to Section 13. My Lords, can I just ask you to see how Lord Diplock put it in De Freitas and Benny, how he described the Constitution? It's a 2453H, because we say this was the traditional understanding, 2453 at H.
Just before we go there, the reason that I would be interested to see the Canadian Bill of Rights would be to see how they reconciled the principle of parliamentary rule and fundamental rights, which obviously is problematic in any constitution.
Yes.
Are you able to help us with that?
Well, I know it is referred to, but how much of it is referred to in the Robertson case, which is the religious case?
Anyway, you'll provide us with a copy.
My Lord will provide you with a copy.
All right, thank you.
But I just want you to see how Lord Diplock puts it in De Freitas and Benny, which was decided in 1974, I think, 2453H. He's talking here of the 1962 Constitution. Section 2 is not dealing with enacted or unwritten laws in force in Trinidad before that date. What it does is to ensure that, subject to 3 exceptions, no future enactment of the Parliament established by Chapter 4 shall in any way derogate from the rights and freedoms declared in Section 1. And he gives examples. Now, my Lords, I submit that was the traditional understanding. You just can't derogate from them, save in certain ways. And that naturally read, in my submission, is saying, you just can't derogate from them. You can't make a major departure from them simply on the basis of proportionality. You just can't derogate from them, save in certain ways. And my Lords, before Suraj, I think I'm right in saying there's no case which raised what you might call the proportionality test. And that's, what, 46, almost 50 years worth of jurisprudence. My Lord, reference was made to the De Freitas for Antigua and the 4-stage test, or the 3-stage test, which is the, as it were, from which the proportionality test in the UK has subsequently been arrived. But of course, Antigua was again another ECHR-based constitution. It's nothing like this constitution at all. My Lords, the essential difference between the two systems, if I can put it that way, the essential differences, if I can just summarize them. First, the Trinidadian Constitution provides for an assessment of the scope of the fundamental rights against the position in which things stood as at 1962 and then 1976. And, my Lords, you get that in particular from the words, there have existed and shall continue to exist. You'll be familiar with those in Section 4. And C2, the existing laws provision in Section 6. And all this is explained in Lord Diplock's various judgments, which you'll have read already. By contrast, the ECHR provides no historical baseline against which to assess the scope of the rights being protected. Secondly, the Trinidadian Constitution uses quite different language. It doesn't talk about derogations, as the ECHR repeatedly does. I think Mr. Riley counted at least 11 times when the word derogate from is used. Instead, it uses a quite different concept of abrogations, abridgments, and infringements. And in my submission, those words are advisedly used. They don't all mean the same thing. Abrogation means just take away altogether. Abridge means cut back or curtail. Infringe, maybe it's something lesser than that, but it must be some sort of substantial interference. Those, I submit, are the meanings to be attached to those phrases. And the Trinidadian Constitution expressly provides for those abrogations, abridgments, infringements to be made, but only with a supermajority or in emergencies. Again, that's not the scheme of the ECHR at all. The ECHR does have a provision for emergencies. I think it's Article 14 or 15. But again, there's no suggestion that government would need a supermajority in those events. And it would have strictly to justify the departure. Now, I would like to say something about that language. In my submission, on the face of it, just coming cold, it doesn't make much sense to say that a proportionate or abrogation which pursues a legitimate aim is not an abrogation at all, which is what Suraj, if as interpreted by the Court of Appeal in this case, would require. And the same with abridgment. More naturally, an abrogation or an abridgment which is proportionate and pursues the legitimate aim is just that. It's an abrogation and abridgment, but it's one that pursues a legitimate aim. I say it's a matter of English.
But I mean, that's to assume in your favour that what the nature of these rights are. If they're qualified rights, and they're qualified on the basis of proportionality, a proportionate measure will not abrogate, abridge or infringe the right.
Well,
hypothesize it won't.
Well, in my submission, it would. A proportionate measure would do so. That's the more natural way of looking at it. I would say, my lords, one could argue the point either way. I accept that, but I say more naturally, an abrogation, something which takes away a right for 6 months or whatever, or a year, I would say is an abrogation of the right. It takes it away altogether. It may be proportionate and pursuing a legitimate objective. But, my lords, but one also, if I can come in a moment to section 5, I don't want to, I'm conscious of the time, but may I explain why I say there's no such thing. An abrogation is proportionate and legitimate is just that. It is not a non-abrogation. If I submit, first of all, one has to look at the word expressly in section 5. The only way you can abrogate, infringe, and so forth is expressly. And that, in my submission, limits the circumstances in which this can take place, and it knocks out the argument there can be some sort of implied power to take away. But, my lords, can I ask you to look at section 5 and the words itself? And I think it's at 1286, my lords.
1287, I think.
1287, yes. And it's section 5, because one has to look at what does the word abrogate mean, and so forth. Looking at the Constitution as a whole, and look at section 5(1).
Sorry, just on that. I thought you just told us it means take away.
Yes. But my lords, in answer to your lordship's point,
right.
Is a proportionate abrogation a non-abrogation, or is it? Or is it just that, a proportionate abrogation, but it still qualifies as an abrogation?
But what I was putting to you is it's not an abrogation. On the theory that's being put forward on the other side, it's not an abrogation at all. It completely, the rights are completely respected in the case because the government acts in a way which is compatible with those rights. It hasn't taken them away at all.
Well, my lords, I'm just trying to say why we say our submission, looking at this provision in section 5, is correct. Section 5(1), except as is otherwise expressly provided, no law may abrogate and so forth. But then, subsection 2, without prejudice to subsection 1, but subject to this chapter and to section 4, Parliament may not. And there are a whole series of things which Parliament may not do. Now, in my submission, these are absolute. These prohibitions are absolute. It's not saying it's not suggesting in my submission in 5(2) that Parliament can authorise arbitrary detention as long as it is proportionate and legitimate to do so and so forth. Again, all the way through, I say these are absolute prohibitions, not prohibitions which are there but can be departed from as long as it's proportionate to do so. And then, now I accept that as you go all the way down to G, you are dealing with essentially legal or litigation or protection from charge against crime and liberty of the subject. But then you get to H. Parliament may not deprive a person of the right to such procedural protections as are necessary for the purpose of giving effect and protection to the aforesaid rights and freedoms. Now, again, I submit what that means is Parliament simply cannot take away these freedoms. Procedural protections for the freedoms. And
sorry, just on that. I mean, surely that's about having access to court to give effect to these rights. So governments can't pass a law saying there shall be no judicial review. Well, because otherwise, how do you enforce your constitutional rights?
Well, I am suggesting that H is covering not just A to G, it's covering all the rights and freedoms, hence freedom.
Yes, no,
I talk about procedural provisions.
Yes.
What content do you give to the words procedural provisions?
Well, my lord, that would be in relation to any. So it would be in relation to any right and freedom, not just those which have been talked about.
But that's what I'm putting to you.
Yes.
The latter part, the aforesaid rights and freedoms, yes, that's all of them.
Yes.
But what is the right that can't be taken away is the right to procedural provisions as unnecessary for the purpose of giving effect to those rights. In other words, as it seems to me, the ability to go to court to say, I have these rights, court, please now enforce them. That's the procedural provision which you have, if you like, an absolute right to. It's equivalent to saying you can't abolish judicial review.
Well, also it would be that, but I'm saying it also. I'm saying that the suggestion in this is that the way it's structured is that the premise of all this is that the rights cannot be taken away. So, prima facie, save is expressly provided. In other words, and what you've got here is a protection for the procedures to protect the rights, and that's an absolute protection. Now, my lords, I also say the natural construction of Section 13, taking it cold, is that it deals with any case in which there is an abrogation, abridgment, or infringement, or put another way, any case where there's a derogation. And my lords, were it otherwise, Section 13 would be reserved only for really rather limited purposes. First of all, it would be reserved to deal with the case where a law is proportionate and pursues a legitimate objective, but somehow, despite that, it is not reasonably justifiable in a society, democratic society, with respect for the fundamental rights and freedoms of the individual. And I respectfully say, in real life, what does that actually add to the protection which is anyway given to Parliament? And I say that the natural reading of Section 13 is it provides for any legislation which you want to pass, which abrogates or derogates from these rights. That's the natural way of looking at it. My lords, I understand Lord Reed's point. There's a difference between justifiable and justified, if I can put it that way. In other words, the government can say, well, I don't have to justify this law under Section 13, I just have to show it's justifiable. And that gives a range of options. But my lords, I submit that... forgive me, my lord.
I think I'm going to have to eat some humble pie. I've been looking at what I said in Bank Mellet, and it is explained there that when the Human Rights Act came into force, the House of Lords adopted the de Freitas formulation as a test of proportionality.
Yes.
And it's since then been refined in light of the particularly the Oakes case in Canada.
Yes. Yes.
When you look at de Freitas itself, it's very interesting. If I just bring it up, what it was actually concerned with was the phrase "reasonably justifiable."
Ah.
Yeah.
So I see, my lord. Yes, and therefore.
And in construing the expression reasonably justifiable in a democratic society, which was the test under the Antiguan constitution, the board was referred to 3 cases in which that phrase, the reasonably justifiable phrase, had been considered. One, a South African case where the court had adopted from the Canadian case law, the 4 criteria that eventually we now know as the Bank Mellet criteria.
Yes.
And 2 cases from Zimbabwe where a very similar analysis had been formulated, drawing on South African case law as well as Canadian case law. So what Lord Clyde then formulated was the first 3 of the Bank Mellet criteria as a test of whether something was reasonably justifiable in a democratic society. Yes. So that really is implying that what we think of as proportionality in Bank Mellet terms is the test in Section 7 and Section 13.
Yes.
In the context of a public emergency in the first instance, and or simply in a society which has a proper regard for individual rights and freedoms.
Yes. My Lord, I mean, obviously, I'm conscious I just need to make my point, so I can, but they will be debated. But we say, is Section 13 on the construction which is put against us of the general way of construing the section, Chapter 1, deals with a very limited type of case. And we say that's an objection to the construction advanced by my learned friends. Section 13, naturally read, has got a fairly broad application, and of course you can deal with proportionality, legitimate aim, and all the rest of it within Section 13. My learned friend, I think it's also been said, and Lord Sales put the other advantage of...
Sorry, but the difficulty isn't so much application of proportionality within Section 13, it's that you need a supermajority to do anything under Section 13. That was the objection that was taken by the majority in Francis.
Yes.
Is that undercuts the power of Parliament in Section 53 to an unacceptable degree that cannot have been intended.
Well, my Lords, I'm not here specifically to defend the majority or minority in Francis. I'm just saying as a matter of proper construction, it doesn't leave too little power for Parliament. It says if you want to abrogate and so forth, you need a three-fifths majority, and the law must be one that can survive a challenge on the footing it's not reasonably justifiable and so forth. We say that's the conscious choice of the legislation, and it makes sense. And, my Lords, one does, in my submission, generally construe constitutions, so to speak, broadly in favour of the human right rather than in a restricted way. But, my Lords, all these are, my Lords, you have our arguments on that. My Lords, another point that's been suggested by my Lord Sales was, well, Parliament, the advantage of Section 13 is it gives a sort of boost or bolsters the defence which can be raised by the state to a challenge. And, my Lords, no doubt it does. I would accept that, but even so, I say that doesn't really give Section 13 all that much weight, because the individual can come along and say it's not reasonably justifiable. My Lords, I just want to make 3 points. This is not specific saying the minority is right in Francis, but general points. What I'm saying does not mean that every limitation which impinges on the fundamental rights and freedoms amounts to an abridgment, abrogation or infringement. I'm not saying that. And if, my Lord, I know I've been criticised for saying different things at different times, but can I just say how I would put it? The interference must represent a reasonably substantial departure from the norm as recognised generally and in particular when the Constitution was passed.
Sorry, could you give us that again?
The interference must represent a reasonably substantial departure from the norm. That is why I say Suraj was rightly decided, because, as Lady Hale pointed out, they weren't departing that far from the norm, either as understood in 1976 or indeed as now. Because the alleged infringements were not major departures. Likewise, the Alain Forte case, the parking restrictions case.
But sorry, I thought in Suraj, isn't that the case where Lord Bingham dissented?
Yes, but on a different point, my Lord. On this point, he said he was reluctant to express a view.
All right.
But he did say that he recognised, of course, that ordinary rules, what was it, paragraph 33, I think.
Yes, 33, 34, I think, in Suraj. He says he would have been reluctant, I think along the lines, reluctant, he didn't want to say anything, but he would have been reluctant to hold that there was an infringement. But he doesn't say on what basis, as I recall.
All right, thank you.
And he does importantly draw attention to the fact that that legislation, in his view, also reflected, the new legislation reflected the dignity of the person, which is caught in the preamble of the Constitution. And he said, bearing in mind the overall pattern of the Constitution, he would be reluctant to say, because one of the problems of this whole debate is I might further A's interests and therefore give A a few more fundamental rights, as it were, at the expense of B, because yes. B might not be able to say quite as many things as B was able to say before. That obviously is one of the problems. And, my Lords, that's not a problem we have in this case, though, because we say this is a quite different situation.
Right, but you are proposing to us a test that applies across the whole board.
Well, my lords, that's as a general test, general test.
And I mean, well, let me press you on it. I mean, isn't one of the difficulties with your test the difficulty of application of it?
My lords, I would say no. It's not a particularly difficult thing to do, and indeed in Suraj itself, Lady Hale justified her decision by reference to saying, as I recall, well, it's barely a departure. There were two breaches, barely a departure in one, and on the other, it was simply introducing into the law of Trinidad and Tobago a commonly recognised exception to, or qualification rather, to people's enjoyment of the right of property. So I say that Suraj, taken on its own, it does not justify, as it were, taking this test even to an extreme, as I would say, extreme case like this. It's just totally different. And, my lords, you have my submissions in writing. I mean, we have put this in writing, and there are different ways of putting it. My lords, we are therefore not saying the position is absolute. I'm very anxious that I'm not being held to a sort of absolutist or originalist position. Second, my lord, this construction does not freeze the Constitution as at 62 or 76 in all respects, or prevent it from being developed gradually by the courts, by the common law courts, as in Panday, or by the legislature. It merely prevents, to use a phrase used on Monday, backsliding, that is to say, the reduction of rights, but they can still progress further. And the third point I want to make is the construction for which we contend does not affect the question of how one should interpret executive action at common law or under delegated legislation, because Chapter 1 is simply dealing with parliamentary action. So one can still rely quite legitimately on ECHR learning when it comes to executive action, if that is appropriate in the context of the given case. My lords, that's the first thing.
Sorry.
Yes.
You said, I think, Chapter 1 is just concerned with legislation?
Well, legislation and presidential proclamation, as I understand it.
But surely the rights in Section 4, which is in Chapter 1,
yes,
are declared for all purposes.
My lord, that is correct. But right. Essentially what the Sections 5 onwards are dealing with,
yes, Parliament.
My lord,
but the point I raised before is that whatever theory we have of how the rights in Section 4 operate, have to take account not only how they operate in a legislative context, but how they operate in the context of action by state officials.
Yes, I would accept that.
Okay.
My lord, my learned friend says my learned friend says, well, none of this matters very much because if you go back to the 1976 Constitution, there were qualifications in existence at the time to the fundamental rights, one of which was Section 105 of the Public Health Ordinance. My lords, you have our submission on that. Can I just show you the 1947 Emergency Powers Ordinance, however, which I forgot, I'm afraid, to show you last time, and that's Supplementary Bundle 1, pages 2 to 4. It's mercifully very short. 1947.
So, sorry, can you give us the
Supplemental Bundle 2.
Thank you.
Sorry, Supplemental Bundle 1, page 2 to 4.
Thank you.
Emergency Powers Ordinance, and then 2 and 3 on page, I think it's not quite clear which page, but anyway, you can see 2 and 3 is the next page. It essentially gives power to the governor to take over, or rather, sorry, to pass emergency regulations in the event of threats, internal threats to the safety of the country. I think it's not just internal, it seems to be any threats to the safety of the country. He has power to make a proclamation. He can declare a state of emergency, and when there is a state of emergency, he can take control of all sorts of things. Fairly, I imagine, typical types of things. Now, my lords, we say this. 1962 comes along. At that time, you have the emergency powers in place. You also have Section 105 in place. They're basically both providing for emergencies. And we say you could theoretically construe the Constitution as preserving both the Emergency Powers Ordinance and as preserving Section 105, even to the extent that they authorise infringements with fundamental rights. Theoretically, you could do that. But we say that's most unlikely. The wording of the Constitution is said there have existed and shall continue to exist the following fundamental rights and freedoms. We say it is totally implausible that the intention of the Constitution was that these emergency powers and effectively the emergency powers in Section 105, so far as they authorised infringements of fundamental rights and freedoms, were still to continue. And we say it is a straightforward de Keyser point. Because if the governor in 1963, let's say, could say, well, never mind about the proclamation and all the rest of it under the Constitution, I'm going to make a proclamation under my emergency powers, one would say, well, what's the point of the Constitution? And likewise, we say in relation to Section 105, if he's going to derogate or abrogate these fundamental rights and so forth, he's got to go down the constitutional route. He can't say, I'm jumping to my other powers. And we say that can't be the intention of the Constitution either. I think Lord Reid pointed out that Section 7 of the Constitution, which is the bit that introduces emergencies, without prejudice to the power of Parliament to make provision in the premise, 1289, my Lord.
Yeah. Sorry, just before we go on to that, thinking about the emergency powers order, if in taking action now under that order, the governor or now the president had to respect the constitutional rights in Section 4, however they are to be respected.
Yes, yes.
The other side would say including a proportionality test.
Yes.
Then the Constitution would be respected in respect of that action without needing to go to Section 7. It would just be the constitutional rights would be respected in the usual way.
Well, my lords, it's possible, but again, we're coming back to the same debate as to what amounts to an infringement.
Certainly, yeah.
In the first place. And my lord, I see your point. If I'm wrong on Surat, can I put it this way? If I'm wrong on Surat, I can see that I'm facing difficulties on all the other points. If I'm right on Surat, I say all these other points follow. I mean, in one sense, I can see it hinges to a certain extent.
All right, thank you.
But anyway, my lords, you have our point, but I was just going to say Section 7, without prejudice to the power of Parliament to make provision in the premise, but subject to this section, and so forth, the President may. So in other words, this Section 7 does, in my submission, say you cannot pass ordinary legislation. It says if you want to do any of the following things. That, I say, includes Section 8.2 dealing with a public emergency where there's an outbreak of pestilence or infectious disease. That's the route if you want to infringe fundamental rights. My lords, I think bearing in mind what I've just, as it were, conceded or accepted, the question is, Surat, the question is proportionality or not, and that's the fundamental question. It may be, everything follows from what I'd say. Can I just say in relation to Panday, my learned friend drew attention to the phrase for good measure in Lord Nichols's judgment. My lord, Panday, of course, is not a case about legislation. He's there talking about the common law development of the law of defamation, essentially. And it doesn't help you construe the existing laws clause, or indeed what the full scope of the fundamental rights and freedoms was in 1976. And just on the existing laws point, if I can just round off with these points, my learned friend referred to the phrase shall not invalidate in Section 6. We deal with all of this in our written case. I don't want to repeat it, but there's a short answer to all of this. Section 6 does not make a saving for regulations passed under an existing law, and it could easily have done so, and you see how we put it. And my learned friend also referred, I think Mr. Hussain referred to Dolan. If I can just say as to that, first, there is no doubt that there is a breach on the faith, we say, an infringement or abridgment, more realistically, of the right to freedom of assembly. And my lords, these aren't referred to in my case, but my learned friend does. one doesn't give the freedom of assembly provision such a narrow construction as to exclude this type of complaint. Can I just give you the references? It's the ECHR itself at 244249 in the Countryside case said it's not just limited to political assemblies and so on and so forth. They wouldn't want to say it's limited, so limited. And in my submission, it would be remarkable if in Trinidad the notion that you needed some sort of permission to gather or reasonable justification to gather as more than 5 people, and notoriously.
Sorry, I thought Mr. Rowe accepted that the assembly right was relevant.
Well, but in that case,
he was making a point about the association right.
In that case, I don't take the point any further. And also in Dolan, it was pointed out that there were 2 ways in which the Secretary of State could have exercised his powers. But the point wasn't run, certainly as I read the Court of Appeal's judgment, to the effect that the second in time piece of legislation had taken over or superseded the first. And they weren't talking about a constitution taking over from a statute. So it was quite a different position. And finally, on the sovereign democratic state point, I accept, as I indicated earlier, that we are dealing with an existing law here. The point simply is this: an unsupervised power, even by an unsupervised power to pass swinging regulations of the sort which you see in 105, without any parliamentary supervision at all, by way of negative or affirmative resolution, is, we say, simply inconsistent with the notion of parliamentary sovereignty. That's it. And that is not affected by the fact that the minister is nonetheless accountable to Parliament. It is simply that this gives the minister far too wide a power, because Parliament just doesn't get a look in. And it's one thing to say, oh, well, people can always challenge it. But, my lords, one of the essence of this case is that people need Parliament to help them before it gets to that stage. Litigation is a dangerous game, as we all know. And that's why we say it's important that Parliament has a real say before this type of legislation, as we...
Well, you're not speaking in the context of Trinidad and Tobago strictly of parliamentary sovereignty, are you?
Yeah. No.
I mean, it's constitutional sovereignty.
It's constitutional sovereignty, but this,
But
the
you're saying it's inconsistent with the legislative role of Parliament.
Yes.
Under the Constitution.
Yes. And so, my lords, those are my submissions. I'm grateful for the time, my lords. We are prepared to sacrifice some of our time.
Yes.
And I do apologise again for the late delivery of, the delivery of today. I think slightly more.
To be honest, the problem isn't so much what we got this morning. It's just we're rather taken aback. I was rather taken aback by the volume of material that arrived Monday.
My lord, I have a yellow card for that, and I totally understand. Those are my submissions.
Thank you very much, Mr. Knox. Well, the court will adjourn now, and I think we can get started on the Maharaj appeal at 2 o'clock.